Good afternoon, friends. My name is Alena Shautsova. I'm an immigration attorney from New York. And today we're going to have our live where we'll be discussing the most recent immigration news. And I, of course, will be answering some of you guys' questions. So please join me. Make sure that you let me know where you're watching from. Type up your name, say hello. We haven't seen each other in about 10 days, I think, right? And I'm sure you miss me. I missed you guys. I missed your questions. So don't forget to type up your question. Let me know what question is bothering you. I've been practicing immigration law in the United States for more than 15 years at this point. Hopefully I can help you out, right? Don't forget also to like and share this video so more people are going to join us and we will be able to have more people in our group. Let me know where you're watching from and let's start. So a couple of interesting things. Some of them you are aware of, I hope, by now. Everybody's talking about them. Thing number one, USCIS raising their fees. Finally, they confirmed that starting April 1st, they will raise their fees, filing fees, for virtually all applications that you need to submit with USCIS. The fees are going to go up. Percentage of the raise depends on the application, but the most significant change is going to be for those who are filing for adjustment of status. Because for you guys, what's going to happen is that you will have to pay now separately for work permit and for travel permit when you file for adjustment of status. Something like from 2007, you did not have to do it. Basically, what was happening from 2007, USCIS, when you pay one fee, would allow you to have work permit and travel permit for free as long as you paid for I-45 form, the full price. But now it's going to change. Now, if you submit your application April 1st and after, you will have to pay separate fees for work permits and for travel permits. It's just life. There is nothing we can do about this. Apart from if we qualify, we can submit for our submit our adjustment of status package earlier. So if your package is received prior to April 1st, you will have this benefit of not having to pay separately for work permit and travel permit. But most importantly, if something happens and you need to renew your travel permit and your work permit, you will not have to pay the fee as well. However, it is extremely unlikely that you would have to file for an extension of the work permit and travel permit. Why? That's right, because now work permits and travel permits are being issued for 5 years. And within this 5 years, chances are your application will be considered, right? So it's very interesting how it all works. And still, it's good to save a little bit of money. It's going to be difference of about $700. Significant difference for most people. In addition to the difference in adjustment of status application and I-130 application, we're going to be looking at about $1,000 difference when we file for adjustment of status. 1 day late, $1,000 out. So think about this. If you can hurry up, hurry up. Of course, there are other applications that will go up in price, like waivers and application for naturalization. Interesting thing with naturalization application, if you can show that you do not make more than 150% of poverty line, according to your household, you will be able to pay much less for the naturalization application. But from my experience, sometimes it's so hard to show that it's just prohibitive to try to fight for this reduced fee. And you're just better off just paying the fee, the full fee, and waiting for your citizenship. So that's news number one. One more piece of very interesting information I wanted to share with you. relates to the decision from the Board of Immigration Appeals, and I may mispronounce it, matter of Aguilar Hernandez. It's important because Board of Immigration Appeals confirmed that if the government files Form I-261, additional charges of removability, that contain date and time when you need to appear in court, that does not cure the fact of notice to appear, which was initially served on you if it did not have date and time. It's extremely important, guys. For those of you who have orders of removal and you're thinking about filing that motion to reopen, and you're thinking that you may qualify for cancellation of removal. Extremely important. Another important case that relates to this issue is being considered by the United States Supreme Court. It has something different at stake. It has something different in the matter of jurisdiction and trying to fight that order of removal by default that you received. But nevertheless, Board of Immigration Appeals finally agreed with the United States Supreme Court that subsequent notice of charges does not cure the fact of notice to appear. Maybe it sounds strange to you. Replay, save this video, because if you do have a motion, and if you do have an order of removal, and you need to file that motion to reopen, it's extremely important that you know this. It may be super relevant to your case, super relevant for you to be able to qualify for cancellation or removal without any headaches. Very, very important to know that. So, of course, we'll have some other interesting news. For example, H-1B rules are changing. According to USCIS, H-1B program is going to be more like fair, that no matter how many employers are trying to sponsor one person, all of you going to have equal chances. That's what they want it to be. That's what USCIS wants it to be. But the rules are changing so that, from what I understand, some people who previously would qualify for H-1B program simply will not qualify for it anymore, just because the rules are changing as to the description who will be covered by a specialized occupation. Of course, I may be wrong. We're going to see how it's all going to be implemented, how it's all going to be unfolded, because sometimes we read the rule and we think one thing, and then in practice, it's a totally different thing. But what you need to know that if you are someone who is going to be filing for H-1B visa this season, and the registration is going to be open shortly, you need to know about the changes, or rather your lawyer must know about the changes, your employer, and if you can, adjust maybe description of the position, be very careful the way you word description of the position and your qualifications. You have to keep these new rules in mind. It's very, very important. Also, the rules are changing as to those who will be covered by bridging, meaning that you have the work permit, you are an OPT, and you cannot start your job starting October 1st. So all these rules, all these changes are coming. You have to stay on top of them. Your lawyer have to stay on top of them, so that you're not gonna, find yourself in a situation when later, when you file for adjustment of status, USCIS says, "Oh, wait a second, you cannot file for you do not qualify for adjustment of status because you made this little mistake here and there." So just stay on top of the rules. Consult with an attorney if you have to. Speak with a lawyer who's working on your H-1B case to make sure that the new rules are not going to negatively impact your case. Now, I will be happy to answer some of you guys' questions. Hi, Haluka, can you kindly, IMK, what is extreme hardships? Can I kindly maybe explain what extreme hardships are? On my website, shautsova.com, I have a whole table of different waivers and hardships. What USCIS looks at when they decide whether or not you qualify for hardship. First, they look at hardships related to one's health, then financials, then economic hardships, but that doesn't limit you. For most of the waivers, most of the applications, USCIS says that they will be looking at all the factors together. So even if there are some hardships that are not specifically articulated by USCIS in their rules, but you can articulate, maybe those hardships are unique for your specific case, USCIS must take it into consideration. So what is extreme hardship in each case is going to be looked at and considered specifically, but usually health-related hardships, emotional hardships as well, financial hardships, hardships related to one's household's economy, right? Money, basically. Even though USCIS says it's not important, they always look at it. Hardships to your family members, if you are the qualifying relative. How, for example, absence of the beneficiary, of the person who's filing for the waiver, is going to influence your qualifying relative's ability to help your relative. All matters, all right? All matters. If you are facing a waiver, please work with a professional, guys. Typically, you have one good chance of making one good impression on the USCIS to show that you have a good case. And waiver usually is your case, is your green card or your immigrant visa. Waiver or need to show hardship means that you have a problem in your case. And if you don't overcome that problem, you're not going to get that green card that you want, right? So what do you want to do? You want to prepare. You want to make sure that you're going to put the strongest case possible to convince USCIS that you will win it. Why? There is no interview for the waiver. You will not have a chance to talk to anybody. You talk to USCIS through paper, through your submission. Hi, James. Hello, Alena. Let me see. Can I highlight it? Okay. Hello, Alena. I got a refee for medical exam 1 month after I submitted. I'm at 39.45 based on green card. Do you think that USCIS may waive the interview? You want me to guess here? Hopefully they will. Typically, if you receive a request for evidence for medical, it means that yes, they would like to grant your case. I just received an approval for a green card for a married couple without interview. And it's not the first time we received that. So it's very typical these days. It means that you did a good job, usually showing that you guys do have a real marriage and you don't have other issues. And then you should receive approval by paper. Now, if your marriage is less than 2 years old, at the time when USCIS is going to consider your case, you're only going to receive a conditional green card. So remember, please, that you will still have to remove the conditions from your green card to be able to file for citizenship. It's very important. Many people relax, they forget that they still need to collect evidence. USCIS still would like to see joint tax returns, statements from joint bank accounts, utility bills, photos, you name it. So until you receive your citizenship, remember that every little paper in your marriage case matters. Make sure to save all the copies and do the right thing. Hi, Mesh. There is a question about WhatsApp. Unfortunately, there is no opportunity for me to connect WhatsApp here. Now, if you guys have more questions, please ask them. This is your chance to ask me questions for free. I'll be very happy to answer them, help you out a little bit, right? We just discussed in immigration news. Hi, Mr. Singh, how to win cancellation or removal case? By creating a very strong record of hardships. That's the only way to win a cancellation or removal case. First, you have to show that you statutorily qualify for it. It means that you've been in the United States for 10 years legally, not just physically, but legally. Service of the notice to appear that has date and time of your hearing stops the accumulation of 10 years, even though physically you could have accumulated more than 10 years. But if you were presented with a notice to appear or order to show cause, your 10 years stop. Committing of certain crimes, arrests for certain crimes, would also stop accumulation of 10 years. Then you have to show you're a person of good moral character, that you do not have certain disqualifying convictions. Then you have to show that you have a qualifying relative. Those relatives can be only green card holder or citizen, parent, spouse, or child under 21 years old. After that, you have to show that that qualifying relative is going to experience extreme, rather exceptional and unusual hardship in case of your removal. After you showed all of that, this is when discretion comes. In the very end, you still have to win your judge based on discretion, that you deserve this green card. I had a case last year where the client agreed to administratively close their case because the judge threatened them, saying the following: yes, it seems you have hardships and you have qualifying relative and you prepared your case very well, but you know that it's a discretionary relief. I see that in 5 years you will be able to file for adjustment of status. Now tell me, why do I have to give you cancellation of removal now, and you're going to grab a visa from somebody else who otherwise is not going to be filing for adjustment of status, rather than simply telling you to wait for 5 years? And the difference in reliefs is going to be like 2 years, because even if the cancellation of removal is granted today, you have to wait for 3 years before the visa is going to be available, just because there are not enough visas in this category for everybody who qualifies. So all this has to be taken into consideration before you proceed, okay? Before you proceed with your application. For some people, cancellation or removal will be the right choice, especially if there are issues of fraud, good moral character, permanent bar, maybe some other grounds of admissibility, which you can convince the judge should not be a problem to finding of the good moral character. Some people, it's maybe not such a good idea. Some people can rather use I-601A waiver to get that visa. Some people can file for adjustment of status. So you should sit down with your attorney and see what is the best option for you. If you guys have more questions, please let me know. I'll be happy to answer them. Don't forget to like, share this stream so more people are going to join us. And hopefully my channel is going to grow. Well, I know it already has a lot of followers on Facebook. We have almost 700,000 followers, maybe more. But you know, I like helping people. It's always fun to have more and more people joining, more positive vibes. All my followers usually give me very positive vibes. I like you guys all. You're like the best group of people ever. Whenever I'm tired or don't feel good, but I know that you got my back. You got my back. You always send me encouraging messages, hearts, and it makes my day. Hi, Shabir. I have my receipt date February 2019. How long to wait? I would not be able to answer this question because I do not know what was filed for you. What type of application or petition was filed for you? Let me know. If you're in some sort of a family preference category, you may have to wait for a long time, okay? You may have to wait for a long time. If you are, just filing for U visa, it's 5-7 years, sometimes you have to wait. So we need to know what is it that you're filing for me to be able to answer your question, okay? Well, if you have more questions, guys, please ask them. I'll be very happy to help you out. U visa. Yes, we have here a U visa. That's right. So it's 5 years. Usually you would have to wait, maybe more. We'll see how soon the government is going to deal with the backlog, because they promised and promised to utilize all U visas that used to be available, but they've never done that. For that reason, we have this tremendous backlog in the U visa category, but hopefully it's going to be resolved sooner than later. Well, guys, thank you very much for watching. Thank you very much for asking questions. Don't forget to like and share this stream. Whenever more news gets available, I will share it with you. For now, remember, fees are going up. If you have something to file, file before April 1st. Don't miss that deadline, because it's just going to be silly for you to spend more money after April 1st if you can do it now. And stay connected. Follow me on Facebook, join on YouTube, and I hope to see you soon.